నమస్కారం. దూరదర్శన్ యాదగిరి ప్రాంతీయ వార్తా విభాగం సమర్పిస్తున్న భారతీయ నూతన నేర న్యాయ చట్టాలపై ప్రత్యేక చర్చా కార్యక్రమానికి స్వాగతం. భారతీయ న్యాయ వ్యవస్థలో కొత్త శకం ప్రారంభం కానుంది. బ్రిటిష్ కాలం నాటి చట్టాల స్థానంలో కేంద్ర ప్రభుత్వం తీసుకువచ్చిన 3 కొత్త నేర న్యాయ చట్టాలు భారతీయ న్యాయ సంహిత, భారతీయ నాగరిక సురక్షా సంహిత, భారతీయ సాక్ష్య అధినియం. ఈ 3 చట్టాలు జూలై 1 నుంచి అమల్లోకి రాబోతున్నాయి. ఈ చట్టాలలో సాక్షుల రక్షణకు సంబంధించి విట్నెస్ ప్రొటెక్షన్ స్కీమ్, అదేవిధంగా విచారణ ఖైదీలకు సంబంధించి పలు కీలక నిర్ణయాలు తీసుకున్నారు. ఈ అంశంపై మనతో మాట్లాడడానికి స్టూడియోలో ఉన్నారు సీనియర్ ఐపీఎస్ అధికారి, CDTI డైరెక్టర్ రాజశేఖర గారు. రాజశేఖర గారు నమస్తే అండి.
నమస్కారం.
భారతీయ నూతన నేర న్యాయ చట్టాలు క్రిమినల్ లాస్లో విట్నెస్ ప్రొటెక్షన్ స్కీమ్, దీనికి సంబంధించి ఎలాంటి అంశాలు పొందుపరిచారు, ఏ నిర్ణయాలు తీసుకున్నారు?
See, earlier in the Supreme Court, in Mahendra Chawla versus Union of India case, they outlined the importance of the witness protection scheme. Witnesses are feared to come to the court to give the evidence against the accused. You can have many instances in like in 2018, the latest case is the Asaram Bapu case, where some witnesses were mysteriously missing. Earlier there was a film actor case who run in the midnight in his vehicle and killed some of the witnesses. That is also there. So they don't come very eagerly to the court to attend the court proceedings, this one. So for the first time in the Bharatiya Nagarik Suraksha Samhita, there is a provision relating to the witness protection scheme. Now according to this one, the state government has to brought a notification for the witness protection scheme. Now what all it includes? First of all, the state government has to allot a particular amount of budget for the witness protection scheme. There is a threat analysis report produced by the SP or the Commission of Police, and this threat involves 3 things. That means 3 categories. First threat on the witnesses is that those who having the death threat. Second is the property threat or his belongings or whatever is claimings, that kind of threat is given to the witnesses. Third one is the harassment, don't come to the court and we will do like this, like kind of a small threats have been there. So these kind of 3 categories have been made as far as the threat analysis report. Now what is the provisions is that now the court can give directions to the police to change the name of the victim or whatever the witness protection. For example, in the victim, we have already Nirbhaya case where the victim name has been changed. Secondly, you have to escort, while escorting them to the court, you take additional protection to the witnesses, and so that they are not harmed. Thirdly, those witnesses in their houses also there should be a regular patrolling. Fourthly, there is an alternative accommodation. For example, if they can be given alternate accommodation, safe and house, safe called as a safe house, then it will be very good. So earlier also, the National Legal Services Authority along with our own organization, that is the Bureau of Police Research and Development, had made a draft on the witness protection scheme. But however, the law commissions also, despite 154th from earlier began also, time and again they are telling that there should be a witness protection scheme, but never it happened in the legal terms. Now it has come very legally in the Bharatiya Nagarik Suraksha Samhita itself, that a particular provision is itself saving on the witness protection scheme. So this will make a fearless witness. Yes. They can come for the prosecution. That is also there. Second thing is the TADA issues for the that has to be given by the for the witnesses by the judiciary or the state government. That can also be stated that yes, they can now come forward and whatever the expenses that has been bared, that is already there. The witnesses who come for the police station, the expenses has to be given by the police. That is already there. But for the witness protection, that is very important because the case has been dragged and the prosecution has to take care of them. So these kind of new provision has helped a lot, will help a lot for the witnesses to come forward without any hesitation and fear because of these small high profile cases that has been come this one. And another thing in the judiciary also, in the witness protection scheme, for example, a witness has come and the other side of the witness does not come, or the other side, that is the prosecution, if the prosecution witness come, the defense side has not been ready, or they are not in a position, they are absent, is the defense side is absent, or they are not ready to take on the cross examine this one. only examination in chief is done and the cross examination is done, then the judiciary can dispense off the cross examination and go ahead with the material records that is possible there in the this one. So this will also help us that the more and more witnesses come forward, and just the absentee witness the trial will not be held up. So it will help the speedy justice also.
అండర్ ట్రయల్ విచారణ ఖైదీల విషయంలో ఈ న్యూ క్రిమినల్ లాస్లో ఎలాంటి నిబంధనలు పొందుపరిచారు?
Yes, very importantly, first of all, there is a new punishment that is called as community service that has been added in the Bharatiya Nyaya Sanhita. Earlier there were only 5 punishments, and the 6th form of punishment is the community service. It is not the first in the novelty, but earlier the courts have given the community service as a punishment, but it was not legally or statutorily placed in the law books. But now community service in 6 type of offences has come. To mention one of the offence is that first time offender who has stolen a good less than 5,000 rupees, return the value of the good, and then the court monitored work and without remuneration beneficial to the community service has been given. So the first time offender. Whereas if he repeats the same offence twice, the stolen thing, even if it is less than 5,000 rupee value, then minimum 1 year punishment is there. So this law takes the both reformative as well as rehabilitative as well as a humanistic this one. This will prevent the overcrowding of the prisons. As far as bail provisions is concerned, first time offender and the offence is not more than 7 years of punishment, not death punishment, not imprisonment for life, then after if the minimum punishment is prescribed, if the minimum punishment is prescribed for that offence, then after serving 1/3 of the sentence he can be get bail. If no minimum punishment is prescribed for that punishment, then after serving 1/6 of the punishment, then it can be released on bail. Earlier, instead of 1/3, it was 1/2 of the punishment. So in this way, this has taken a leniency for the first time offenders. But other thing is also, even if he is a first time offender, but the accused is less than 16 years of age, then this provision of 7 years above imprisonment for life or death would not have been come into the picture. That means to say that a child 16 and years below, he has committed a murder or a heinous offence more than 7 years or imprisonment for life or death, then the bail provision would have been good for them. That means after serving 1/2 of the punishment, he could have come out of the jail. Now that 16 years has been enhanced to 18 years of age. So this is a very good provision. This will prevent the overcrowding of the prisons, and also first time offenders, there is a lot of opportunity to get them rehabilitated. Yes.
ఎస్ విట్నెస్ ప్రొటెక్షన్ స్కీమ్ సాక్షుల రక్షణ పథకం ఇది ఇంప్లిమెంట్ చేసిన తర్వాత జ్యుడిషియరీ సిస్టంలో న్యాయ వ్యవస్థలో ఎలాంటి మార్పులు వస్తాయనుకోవచ్చు?
Yes, one thing we can expect more and more prosecution witnesses coming to the court. As I already explained, now if the one of the witness has come to the court, the other witness or the other counsel, other side has not ready to examine him, or they are not absent, they are absent to the court, then this witness why he has to suffer for the expenses and for the day? Then his cross examination can be dispensed provided if the examination in chief has been done. That means witness cross examination needs to be done, but the other party is not present or not ready, then his examination in chief is taken on record and dispense off with the examination cross examination part. Second thing, that there will be no more stringent facility for their protection as well as for more attendance, because now e-summons have come for them. E-summons, earlier it was only adult male member of the family. Now any adult member of the family can be given summons, because many of the witnesses could not come because during that time they did not get the hard copy of the witness. Now the court will issue a witness the summons, and the summons can be served electronically and to any adult member of the family. Only thing, in the court as well as in the police station, mention a diary or a register where you write the names and addresses. So this has a lot of effect, especially in remote areas. Witnesses don't find easy to travel to the courts and all those things. By e-summons and all those things, it will prevent them further struggling. Second thing, it means the witnesses coming again and again, because the defense or the prosecution take the examination of the witnesses many a days, so they need not to come many a days now. Once they are examined, the other party is not in power. Another important thing is that only 2 adjournments are provided in this Bharatiya Nagarik Suraksha Samhita, out of the control of the out of beyond control of the parties, and the other party has no objection, then only 2 adjournments are possible. So this also prevents that more and more adjournments are not taken by either of the parties, and the speedy justice is possible, and the witnesses are need not to come and again, and just for because we already say that a new evidence has been come, again call the new witness, that hassle will not be there for the witnesses, which will help the speedy justice and the speedy trial.
ఎస్, ఇక్కడ విట్నెస్ సాక్షులు వర్చువల్గా కూడా కోర్టుకు హాజరు కావచ్చు అనే ఒక కొత్త నిబంధన కూడా ఇందులో ఉంది.
Yes, so the witnesses, for example, one already the expert evidence under the 39, if the document is undisputed, or the whatever the documents they produce, it is undisputed, or if it is not disputed within 30 days by either of the party, then it is deemed to have been accepted, and those expert witnesses need not to come. Second thing, even for the accused also, they need not to come to the court while submitting the charge sheet or framing of the charges. That has to be done through audio video electronic means. While arrest also, now only first time you produce before the magistrate, second time they can produce electronically. So another thing, but person in trial in absence is also there. That means to say that person has not come forward, or is untraceable or absconder. The lawyer is given for him, and where that time the sentence can also be given in absence of the accused, but to prefer an appeal thereafter in the higher forum, he has to be physically present. So in the judiciary also, using the audio video electronic means, witnesses, and even during the investigation case also, person below 15 years, women, physically handicapped, acute illness, above 60 years of age, these people are exempted to attend the police station, but if they are interested to come to the police station, that's okay, otherwise there is no thing. Already the rape victims, they are not compulsion, and they are not compulsion to come to the court to give their statement or give the complaint. So for example, the rape victims has to be compulsorily be attended by the lady magistrates also, if not, at least by a presence of a lady officer should be there in the court. So these are the provisions that make the very clear and very easy for the witnesses to attend wherever they are, and in a easy manner, and there is no hassle that they need to come to the court 1 day, 2 day, 3 day, cross examination going on for days, weeks, and all those things. This hassle has been stopped, especially in this one, because of the limited adjournments, because of the audio video means, and e-summons and all those things. This has been made very clear and very easier for the speedy justice.
రైట్, థ్యాంక్ యూ సార్. సాక్షుల రక్షణకు సంబంధించి WPS పథకం గురించి, అదేవిధంగా విచారణ ఖైదీలకు సంబంధించిన వివరాల గురించి చక్కగా తెలియజేశారు. థ్యాంక్ యూ సార్.
ధన్యవాదం.
కేంద్ర ప్రభుత్వం తీసుకొచ్చిన 3 కొత్త నేర న్యాయ చట్టాలు భారతీయ న్యాయ సంహిత, భారతీయ నాగరిక సురక్షా సంహిత, భారతీయ సాక్ష్య అధినియం. ఈ 3 చట్టాలు జూలై 1 నుంచి అమల్లోకి రాబోతున్నాయి. ఈ 3 చట్టాల్లో కూడా సాక్షుల రక్షణకు సంబంధించి విట్నెస్ ప్రొటెక్షన్ స్కీమ్, అదేవిధంగా విచారణ ఖైదీలకు సంబంధించి తీసుకున్న నిర్ణయాలను గురించి తెలుసుకున్నాం. నూతన నేర న్యాయ చట్టాల్లోని మరొక అంశంతో మళ్ళీ కలుద్దాం. నమస్కారం.
You can watch Doordarshan's national channel on one